Hello everyone, it's Aprilia and welcome back to my channel. So today I'm going to tell you about how does the unseaworthiness doctrine apply after an accident. Okay, making an unseaworthiness claim allows workers to recover damages from the operator of an unsafe vessel where they suffered an injury. You have the right to compensation if you are a seaman hurt while working offshore on an unsafe vessel. Through obtaining this compensation is not as easy as it often could be. Contact a maritime right lawyer to find out what you deserve. A maritime right lawyer makes it easier for you to focus on recovery instead of protecting your rights or fighting for compensation alone. Let a maritime accident lawyer to navigate the path to compensation while you focus on recovering from your injuries. And then the unseaworthiness doctrine. When seamen suffer an injury during their services on a vessel, they are eligible to take action in three distinct ways. They are as follows. The first is maintenance and cure, and then the Jones Act, and the last is the doctrine of unseaworthiness. The unseaworthiness doctrine is one law that enables offshore oil workers, harbor workers, longshore workers, and other sailors or seamen to pursue compensation from the owner of the ship they were serving when their injuries occurred. Rather than seeking compensation solely from their employer, this rule allows seamen to pursue compensation from the ship owner. Bringing a claim under this unseaworthiness doctrine often involves leveraging the Jones Act. This act allows seamen to sue their employer for failing to offer a safe workplace. To levy such an action, a seaman must prove that the ship owner or employer failed to provide a reasonably safe working environment on their ship. Through other claims, seamen stands to recover maintenance and cure, which provides medical treatment and living expenses to seamen as they push to recover from their injuries or illness. And then defining unseaworthiness. A vessel with parts or equipment not in a condition appropriate for its intended purpose can be deemed unseaworthy. The vessel doesn't need to be at risk of sinking, nor must it be incapable of navigation water. Furthermore, unseaworthiness doesn't imply that the entire ship is dangerous. Instead, minor aspects of the ship can be dangerous, and the unseaworthiness doctrine still applies. For example, a vessel with a ladder that doesn't feature appropriate footholds or grip might make it unsafe to operate. This standard shows how a seemingly unimportant lack of proper functionality can make a ship unseaworthy. Other examples of unseaworthiness include, the first is heavily used and damaged equipment that no longer serves its intended purpose effectively. And then the second, lack of correct equipment such as safety gear. And then number three, the presence of equipment that no longer works properly. Number four, equipment installed in an improper way. And then number five, hazard that may cause a slip, trip, or fall accident. And then number six, or the last one, is improper signage that prevents workers from being warned of hazard. Improper training. The physical state of a ship is not the only determining factor when it comes to unseaworthiness. If you are aboard a vessel, that vessel is subject to U.S. labor laws. Therefore, they must comply with all OSHA and Coast Guard regulations, including proper training requirements. If workers don't receive proper training before they begin work on the vessel, an accident is more likely to occur. Therefore, the presence of untrained seamen makes the vessel unseaworthy. Likewise, having too few crew members or requiring too many work hours can lead to an unsafe work environment. Unseaworthiness includes a lack of proper supervision and poor implementation of proper safety protocols. If any of these issues on the ship injure you may file a claim under the Unseaworthiness Doctrine. Not doing so will prevent you from recovering full compensation from your negligent employer. Vessels must be seaworthy if they operate. Ship owners must, by law, provide a seaworthy vessel if they go to sea without ensuring their ship is seaworthy. They will be subject to Unseaworthiness Doctrine claims. To succeed in an Unseaworthiness Doctrine claim, seamen must prove that an unseaworthy condition injured them. Doing so is not always easy and requires a maritime law attorney. Keep in mind that plaintiffs don't have to display evidence that ship owner's negligence is what caused the ship to lose its seaworthiness. They also don't have to show that the ship owner was even aware that the ship was not seaworthy. On the other hand, with a Jones Act claims, the opposite is true. Seamen must prove that their injuries arose explicitly from their negligence of their employer or one of their workers to receive compensation under the Jones Act. Okay, the Jones Act. What is the Jones Act? Well, the Jones Act is a federal law that helps regulate maritime commerce in the U.S. Under this law, goods shipped within the U.S. must get transported on ships built, owned, and operated by U.S. citizens and permanent residents. This law primarily benefits merchant marine in the U.S. And then the Jones Act is technically protectionist law. While it's focused on maritime commerce-related issues, it also offers seamen additional rights while working. This right includes the right to seek damages from the ship owners, captains, or crew members when work-related injuries happened. The Jones Act offers sailors protection that provide legal recourse when hurt aboard a vessel. Okay, that's all for today. I will continue my explanation in the next video, so don't forget to subscribe this channel and don't forget to like, comment this video. See you in the next video and